My name is Sandra Wilkes. I'm a program manager with the Hemophilia Federation of America. We also have on the webinar tonight as staff Elaine Chan, one of our program coordinators, and Michelle Berg, Director of Programs for HFA. And thank you for attending. This definitely seems to be a very compelling topic for lots of our families in the bleeding disorders community, and looking forward to getting some good information tonight from our speakers. Before we get started, I'd like to go over a few webinar pointers and helpful hints. Tonight's webinar will last approximately 1 hour. We welcome your participation and questions. However, your audio will be muted by our webinar system for the duration of tonight's presentation, as this helps eliminate background noise that may disrupt the presentation. If you have a question, we encourage you to use the question box on the bottom right of your control panel. I will then pass those questions along to our speakers. Throughout tonight's presentation, there are several audience participation or poll questions. When the questions appear on your screen, you will have the opportunity to answer those anonymously, and then we will share the audience's feedback. And finally, HFA would like to acknowledge Novo Nordisk and AHF for their support of our Families program. The title of tonight's webinar is Hi-Ho, Hi-Ho, It's Off to Work, I Don't Go. Our speakers are Ann Henry and Jules Peon. Ann is a trial attorney with the Chicago District Office of the U.S. Equal Employment Opportunity Commission. During her time at the EEOC, Ann has litigated pattern or practice discrimination cases alleging sexual harassment, race discrimination in hiring, and sex discrimination in hiring. She also has litigated individual and class cases involving claims of sexual harassment, racial harassment, national origin discrimination, and harassment, retaliation, disability discrimination, and religious harassment and discrimination. Ann is a member of the American Bar Association Labor and Employment Law Section's Employment Rights and Responsibilities Committee, where she is the public co-chair of the Statutory Rights Subcommittee. Ann received the Federal Bar Association's Younger Federal Lawyers Award in 2009. Prior to joining the EEOC, she was a law clerk for the Honorable Robert J. Tillman of the United States District Court for the Central District of California. She received her JD with honors from the University of Chicago Law School in 2000 and a BA in political science from Yale University in 1997. Jules Peon is a senior investigator with the U.S. Department of Labor and handles most of the family medical leave complaints handled by the Chicago District Office. He began working with the federal government in the Department of Justice Immigration and Naturalization Service at JFK International Airport as an immigration inspector at the Port of Entry. He then transferred to Portland, Oregon as an INS status verifier and information officer. He transferred to the U.S. Department of Labor in 1997 and has worked in the San Diego and Boston offices before moving to the Chicago District Office. Jules is originally from New York City and holds a bachelor's degree in liberal arts from Queens College, New York. And with that, I'll hand it over to our speakers, and Ann is up first for us tonight.
All right, thank you. So I'm going to be talking about the Americans with Disabilities Act and the Genetic Information Non-Discrimination Act, and then Jules will talk about the Family Medical Leave Act. And I think actually our the first thing tonight is a poll question.
Awesome. So we will launch that poll, and audience members, you're welcome to vote on this and kind of let us know who you are. Are you a parent of a child with a bleeding disorder? We'll give you just a second to answer those. And it's 100% voting. We have 75% of our audience is a parent of a child with a bleeding disorder tonight, Ann.
All right, thank you. Right. So the Americans with Disabilities Act makes it illegal to discriminate against a qualified individual on the basis of disability in job application procedures, hiring, firing, promotions, pay, training, and other terms, conditions, and privileges of employment. It also prohibits employers from asking certain types of medical questions to applicants and employees and limits whether an employer can require a medical exam of an employee. The ADA applies to all private employers and state and local government employers who have 15 or more employees, and it applies to employment agencies and labor organizations like unions. The Rehabilitation Act, that contains provisions similar to the ADA, prohibits employment discrimination by the federal government on the basis of disability. The next slide. So the ADA, oh, can you go back one? Yeah, there you go. So the ADA contains a broad prohibition on discrimination, which I just read, and then the statute further defines what it means to discriminate against someone on the basis of disability with some specific types of discrimination. I'm going to talk about two of those. The most relevant to families with children with bleeding disorders is what's called the association provision. And that defines discrimination against a qualified individual on the basis of disability to include excluding or otherwise denying equal jobs or benefits to a qualified individual because of the known disability of an individual with whom the qualified individual is known to have a relationship for association. And I'll talk some more about that. And then the ADA also defines discrimination to be not making reasonable accommodations for applicants and employees unless doing so would be an undue hardship to the employer. And reasonable accommodations can include things like assisted devices, job restructuring, allowing part-time or modified work schedules, providing medical leave, making facilities accessible, and that's just an example of a few. There are many others. Next slide. So the association provision protects applicants and employees on the basis of their association or relationship with an individual with a disability, whether or not the applicant or employee is himself or herself disabled. And the most common situation that this applies to is discrimination against someone who has a spouse or child who has a disability. The statute, though, isn't limited to family relationships and covers really any type of association or relationship. So, an example of something that would be covered under the association provision that's not based on a family relationship is that it would be illegal for an employer to fire an employee if it found out that the employee was volunteering to work with people with HIV or hepatitis or some other communicable disease because it was afraid that the employee would contract that disease. And the purpose of the association provision is to prevent employers from acting on these kinds of stereotypes and assumptions about people who associate with people with disabilities, like assuming that the employee will need to take leave or that the employee's performance will suffer because they're stressed by their family member's condition, or that would be costly for the employer to employ somebody who has a relative with a disability. Next slide. So some examples of the types of actions that are unlawful under the association provision include not hiring an applicant who discloses to the employer that they have a child with a disability because the employer thinks that the employee is going to be distracted or miss a lot of work. Similarly, if an employer found out that an employee had a child with a disability and fired that person for that reason, that would violate the association provision. The association provision also applies to promotions. So if there was a part-time employee who had a child with hemophilia and was qualified to be promoted to a full-time position, it would be illegal for the employer to deny that promotion because they just assumed that the employee wouldn't be interested or wouldn't be available for full-time work. The association provision also makes it illegal to deny or limit health care coverage because of a relationship with someone with a disability. So an employer can't deny health care coverage. If an employer offers health care coverage to its employees, it can't deny health care coverage to someone who has a spouse or child with a disability. And it can't offer coverage on different terms and conditions than it offers to other employees. So for example, if it offers family coverage, it couldn't deny that to someone who has a relative with a disability, or it couldn't deny prescription drug coverage or charge higher premiums. It also would be illegal for an employer to fire an employee because he has a child with a disability or because his child with a disability has incurred really high medical costs that the employer ends up either having to pay because they're self-insured or because the premiums for the company's health care plan go up. The association provision also prohibits harassment, and I haven't seen any cases where this has occurred, but there are cases out there where caregivers, typically women, are harassed because of their caregiving responsibilities, and I could see that happening in a situation where somebody has a relative with a disability that maybe a supervisor would harass somebody about not being dedicated to the job or not being a team player, or sort of holding them to higher standards, scrutinizing their work more closely, yelling at them for trivial things that other employees are allowed to get away with. So next slide. So we have another poll question.
Okay, we're getting that going here. Do you think any employer has discriminated against you? Sorry, there's a typo there. So do you think any employer has discriminated against you because you are a parent of a child with a bleeding disorder? And you can vote yes or no on that. I'll give everybody a second here. And we're 50-50 of our participants believe that yes, they have been discriminated, or no, they have not.
Okay, well, I'm glad a lot haven't. I'm distressed that a number of people have. So I've just talked about some of the things that the association provision prohibits. Now I'm going to talk about some things that are, unfortunately, are not protected by the association provision. So I mentioned before that the ADA requires reasonable accommodations to qualified individuals. This provision, though, only applies to people who are disabled and doesn't apply to people who are associated with someone with a disability. So this means an employer doesn't have to provide reasonable accommodations to people who have relatives with a disability. The next slide. In particular, and I know this is a concern to families with bleeding disorders, is that the employers are not required under the ADA to make exceptions to their leave or attendance policies or to provide any kind of modified schedules for employees who are associated with someone with a disability. So it wouldn't violate the ADA if an employer disciplines or fires an employee who's violated the company's leave or attendance policies, even if the reason they've done so is because they're caring for a family member who's disabled. Next slide. So just a few examples of this to illustrate. A lot of employers out there have what are called no-fault attendance policies, where if you get a certain number of absences or accumulate a certain number of attendance points for any reason, you can be fired. Under the ADA, an employer doesn't have to excuse those absences that are accumulated because an employee was gone from work due to their child's disability. Now, this is if the employee himself was disabled and were gone from work because of their disability, it's likely that the employer would have to make exceptions to attendance policy as a reasonable accommodation unless there was some sort of undue hardship in doing so. Similarly, an employer doesn't have to provide leave to an employee who has a relationship with someone with a disability beyond what's required under the Family Medical Leave Act, which Jules will talk about more. If you've used up all of your leave under the FMLA for the year and you need additional leave, the ADA doesn't require that the employer provide that to you. Now, if somebody is taking leave because of their own disability and uses up all their FMLA leave, the ADA, depending on the circumstances, may require that the employer provide additional leave as a reasonable accommodation, even though they're not required to do so under the FMLA. Similarly, an employer isn't required to change its working schedules to accommodate somebody's need to care for a disabled family member. None of this is to say that the employer couldn't voluntarily agree to do these things, or that you can't, that there's anything wrong with you asking for your employer to accommodate your need to take leave or to change your schedule. I'm sure there are employers out there who, if you're doing a good job and getting your work done, that they'll work with you because they, employees want to retain good employees, so they may be flexible. It's just really going to depend on the attitude of your employer and your particular job and that sort of thing. But the point of all this is, while the employer can do that, they're not required to make any of these kinds of accommodations under the ADA. The next slide. So one thing an employer can't do under the association provision is take action against you because they think you're going to be absent in the future. So they can fire you if you violated the attendance policy in the past, but they can't fire you because they think, oh, this is probably going to happen again. I'm just going to fire John before he needs to ask for more leave to take care of his kid. That's illegal under the ADA. And I actually found an example of this from a case that just came out early this month. And what happened there is the plaintiff had a daughter who had breathing problems and was hospitalized. And when she came back to work, her supervisor fired her. And when doing so, the supervisor told her he needed someone who didn't have kids and asked her, how can you guarantee me that 2 weeks from now your daughters are going to be sick again? So what is it, your job or your daughter? In that case, the court said that's smoking gun evidence that the employer took this action because of the woman's disabled daughter and concerns that the woman was going to have to at some point take leave again. That is clearly prohibited by the association provision of the ADA. Next slide. Although an employer doesn't have to provide any kind of leave based on the association provision, what it does have to do is if it has leave policies or provides leave, it has to do so and treat employees who are taking leave because of a relationship with somebody with a disability the same as they would somebody who's taking leave for other reasons. So for example, if an employer provides a certain amount of unpaid leave that people can take for family or personal reasons, if it grants one employee's request to take the afternoon off to attend a child's school program, but denies another employee's request to take time off to take his child with hemophilia to the doctor, that would violate the association provision. And if instead of asking for time off, the employees were asking to come in late or work through lunch or to stay late, then to cover the missed time, and the employer allowed the employee who's going to the school program to do that, but not the employee going to the doctor, that would violate the ADA as well. Next slide. So in order to qualify for protection under the association provision, your employer has to know two things. They have to know about the association or relationship and know that it's with somebody who has a disability. And for showing that somebody has a disability, I think for people with bleeding disorders, I don't think it's going to be difficult to do under the ADA, but I just wanted to go through this quickly so that you're aware that the ADA has a very specific definition of what it means to be disabled. And there are 3 different ways you can show disability. One is to show that the person has a physical or mental impairment that substantially limits one or more major life activities. The second is having a record of an impairment. And that situation covers scenarios where somebody doesn't currently have an impairment, but maybe in the past they were treated for cancer and they've been cured and are remission, so they have a record of a past impairment but not a current impairment. And then the third situation is being regarded as having an impairment. And that's when the employer either rightly or wrongly believes that somebody has a disability. In some cases, it could be that somebody has no impairment at all, but the employer assumes that they do. So under the first prong, if we can go to the next slide, in order to show that an individual has a disability, you have to show that they're substantially limited in a major life activity. So substantially limited is a little bit hard to define. Sort of the best I can do is the EEOC has defined it to say that an impairment substantially limits a major life activity if it limits the ability of an individual to perform a major life activity compared to most people in the general population. And the ADA is supposed to be interpreted broadly in favor of finding that somebody is disabled and substantially limited, entitled to protection under the statute. So an impairment can be substantially limiting. It doesn't have to be limiting all the time in order for somebody to be considered disabled. So there are lots of impairments out there that are episodic or flare up from time to time and then subside. Epilepsy is one, multiple sclerosis can be another. There's lots of examples out there of this, but for that kind of impairment, when you're considering whether it's substantially limiting, you consider it in its active state. So for example, with epilepsy, when somebody's having a seizure, and then you look at it, are they substantially limited while they're having a seizure? And if they are, they're considered disabled, even though maybe most of the time they're free of seizures. And finally, when you're considering whether something's substantially limiting, you don't take into account mitigating measures like medication, prosthetics, or assistive devices. So if somebody has diabetes or, say, schizophrenia, and they're taking medication that does a good job of controlling their disorder, you don't look at it when they're on medication, but look at what kind of state they would be in if they weren't taking medication, and if they weren't, whether that would be substantially limiting on a major life activity. So the next thing to talk about then is major life activities. So the ADA covers two different kinds of things. One are activities, which you can see here are things like seeing, hearing, sitting, lifting, working, breathing, speaking. And then the next category are, then on the next slide, are major bodily functions. And so, for things like bleeding disorders, some bodily functions I can see being at issue would be hemic or blood function, maybe circulatory function. I think musculoskeletal function could come into play. For diabetes, somebody would be limited in their endocrine function. Cancer would inhibit normal cell growth. The next slide. So I know one issue people may be wondering about is whether they have an obligation or when they should bring up to their employer that they have a child with hemophilia or some other bleeding disorder. And you don't have any obligation under the law to do that, and actually what we're going to discuss right now is that it's illegal for an employer to ask questions to try to find out if you have a family member who has a disability. This obviously is something that is up to you and how what you can gauge from an employer or potential employer, but my advice would be not to bring the issue of having a child with a disability or a family member with a disability or, frankly, your own disability up to an employer until there's a need to. Until you need leave or need some kind of scheduling issue, or if it's an issue of your own disability that you need some kind of accommodation. Otherwise, if it's not affecting your work, I don't really see any need to bring it up to an employer. So I wanted to talk now about the statutes that deal with, or provisions that deal with medical inquiries and medical exams. So it's not entirely clear to me whether the ADA actually prohibits an employer from asking an applicant or employee questions about whether they are designed to get at whether they have a relationship or association with someone with a disability. The ADA says that you can't ask job applicants any questions at all about whether the applicant has a disability. And for employees, you can't ask those kinds of questions unless it's job-related and consistent with business necessity. But those provisions just deal with asking an applicant or employee about their own disability. I'm not sure if they cover a situation where an employer is asking questions to try to find out if you have a relative with a disability. I think there's an argument that those questions should be barred under the ADA, but I can't absolutely say for sure. I've looked to see if I can find cases on that or any kind of guidance, and I haven't found anything definitive. But go to, actually, if we can skip this slide, we can skip that one if we go to the next slide. Even if it's not clear under the ADA whether it's legal to ask questions to try to find out if you have relatives with disabilities, the Genetic Information Non-Discrimination Act of 2008, or it's called GINA, clearly makes it illegal for employers to ask those kinds of questions. So GINA prohibits employers from using genetic information, and it also restricts the ability of employers to acquire genetic information. And this applies to private employers with 15 or more employees and state and local governments, as well as federal government agencies and Congress. So the next slide. So genetic information under GINA is defined, as you see on the slide, and includes some obvious things like an individual's own genetic test or family member's test or someone's request or receipt of genetic services. The biggest category of information, though, and something that most people may not naturally think of as genetic information, is that GINA defines genetic information to include the manifestation of a disease or disorder in family members. And this includes not just disorders or diseases that have a genetic component and are inherited. It includes any type of disease or disorder, which means that under GINA, an employer can't ask questions to try to find out, or can't ask questions related to your family medical history is essentially what this provision means. And family is defined very broadly under GINA. So it includes your spouse, children, adopted children, parents, aunts and uncles, cousins, grandchildren, grandparents, and goes out to relatives of the fourth degree, which means that it bars asking about family medical history going as far back as your great-great-grandparents and as far out as your first cousins once removed, which are the children of your first cousins. Next slide. So GINA prohibits a covered entity from requesting, requiring, or purchasing genetic information of an applicant or employee. Like I said, this means that an employer can't ask questions about your family medical history, including questions trying to elicit information about whether you or any of your relatives, your children, have any kind of medical conditions. There are 6 exceptions, though, to this general rule that where an employer doesn't violate GINA if it does acquire genetic information. I'm going to talk about those next. So there are, like I mentioned, there are 6 exceptions under GINA to acquiring genetic information. I'm just going to talk about the really 2 of those, though, that are the most common and sort of most relevant here. The first is that an employer doesn't violate GINA if they acquire genetic information inadvertently. So, for example, if you're talking to a coworker and a supervisor overhears you mention something about your child's hemophilia, that doesn't violate GINA for the employer to now have that information. It would violate GINA, though, if the supervisor starts asking you lots of questions about, how severe your child's condition is, what kind of treatment do they get, and that sort of thing. That then moves it from the inadvertent category. It would also be inadvertent if a supervisor asks sort of a general question, how are you doing, how are your kids doing, and you respond by mentioning something about your child's medical condition, or any family member's medical condition, because that kind of general question about how you are isn't the kind of thing that normally or would necessarily be expected to get an answer where somebody's talking about medical issues. The other exception to where an employer is allowed to acquire genetic information that I wanted to mention, and that Jules will be talking about more, is that if you're seeking family medical leave under the FMLA, the employer is allowed to get information to find out if you're taking leave for your own serious health condition or a health condition of a family member. So if you're seeking health condition of a family member, at that point they can find out information about your family member's medical condition. Next slide. So even if an employer gets genetic information legally, it's illegal for the employer to actually use that information in any way to make employment decisions. So all of the actions that I talked about before, that where it would be illegal under the ADA for an employer to take action because of an individual's relationship with somebody who has a disability, those same things would be illegal under GINA as well if the employer is doing them because of the family medical history of the employee or because of the medical conditions of the employee's family. So if an employer fires, doesn't hire, demotes, doesn't promote, denies or limits health care coverage, or discriminates in any way because the employer applicant has a child with hemophilia, the employer has violated GINA. Next slide. Both the ADA and GINA have provisions that make retaliation illegal. So it's illegal to retaliate against somebody who's complained about discrimination under the ADA or GINA, or filed a charge, or testified, or participated in an investigation or proceeding. And this covers complaints that somebody makes to their employer or to the EEOC or some other anti-discrimination agency. Next slide. So if you think you've been discriminated against in violation of ADA or GINA, and you want to make a claim against your employer, the first thing you have to do is file a charge of discrimination with the EEOC or with a state or local anti-discrimination agency. You can't just go off and run to court and sue. You have to go through this complaint process first. So you have to file a complaint with the EEOC, and if you want to find where your local EEOC office is, you can go to our website. It's eeoc.gov. And it's very important that you pay attention to the deadlines for doing that. The deadline for filing a charge with the EEOC is 180 days from the date of discrimination, or 300 days if your state or local anti-discrimination law also covers the same type of discrimination. So I'm in Illinois. We don't have a statute that prohibits genetic information discrimination, so employees have 180 days to file a charge. But we do have a statute that prohibits disability discrimination, so employees have 300 days to file a charge. In some cases, these actions can violate both statutes, so you want to pay attention to the deadlines in your state so that you preserve any rights that you have. And then just finally, I just have cites here to the ADA and GINA if you actually want to read the statutes. You can also find them on EEOC's website. And I have some websites here that have on the EEOC's websites that have more information about disability and genetic information discrimination. And then ADA.gov is a website run by the Justice Department that deals with the Americans with Disabilities Act. All right, thank you.
Thank you, Anne. We can take a minute here. I don't have any questions currently for you, but if anyone has any questions and would like to start thinking about those and sending those in via the questions box, that would be a great time to do that now. And then after Jules presents, then we will take a few minutes to answer any questions that the audience may have. So with that, Jules Peon from the Department of Labor will talk with us now about the Family Medical Leave Act.
Hi, everyone. Here on the first slide on the bottom, you're going to see the general information for the Department of Labor, so that's the general number. I'm also going to give you my number, so if you have any questions in the future, you can contact me. So my direct number is 312-771-0962. Next slide. Next slide. And next slide. This slide, what I wanted to mention was the communication between the employee and the employer is essential, and later on the slides, there are going to be slides about employer's responsibility and employee's responsibility. So it's good just to keep your employer informed if you know that you have a serious health condition and that you're going to take some leave. This way they can't hold that against you by saying we weren't informed and we didn't know. So again, just communication is key. Next slide, please. Next slide. The slides are just information so that you can see and you can have them. But I'll go through some of them fairly quickly. So this is what we're going to discuss, the employer's coverage and the employee's eligibility, the qualifying reasons, the amount of leave, and again, the employer's rights and the employee's rights and responsibilities. Next slide. And we have a first poll question. Do you believe you work for a covered employer? Yes or no?
I'm launching that poll right now, so we'll get our attendees' votes. Okay. Looks like everyone has voted, so 100% believe that they do work for a covered employer.
Oh, okay, that's good. Next slide. So in the private sector, this is what a covered employer is. You have to have more than 50 employees. And that's basically all that employer needs. There is something about a 75-mile radius, so meaning that if an employer has an employee with, let's say, 5 employees, but within 75 miles there's another 50, well, those 5 employees are covered. However, if an employer has 2,000 employees and their location, let's say, is in Chicago, but then in Denver they only have 4 employees, since that's more than 75 miles, those 4 employees, unfortunately, they don't have, there's no coverage there. Next slide. The employee eligibility, so with FMLA you have 2. You have a coverage, which we just discussed, and the employee eligibility is you have to work for them for at least 12 months. The 1,250 hours, I always tell people if you work more than 29 hours, you have that, 29 hours a week. It's a little over 1,250 hours, so you meet eligibility then. So the employee has to meet eligibility. Next slide. I'm just going to skip this slide. I don't know if there's anybody that works for an airline, but again, you have my phone number. This is a qualifying reason for FMLA, so it's for the birth of a child or the adoption or foster care of a child, to take care of your spouse, daughter, or parent, and also for your own serious health condition. So, this is the main qualifying reasons why you would take FMLA. Next slide. So here it discusses what a parent is, what a spouse is, and of course they updated the regulation and the law for same-sex marriage under spouse, and then the son or daughter. And next slide. So for the birth of a child, and there may be another slide that discusses this also. We'll skip because I'm going to explain it here. So if you have the birth of a child or the placement of a child, that works a little bit different with FMLA than the other laws, meaning that when it's for the birth of the baby, you have to take the 12 weeks consecutively. You cannot break them. So if it's if you have an illness, then you can take it for the illness, and you have intermittent leave, you can come back and forth on your leave depending on what the doctor says. But if it's for the birth of the child, you have to use all 12 weeks. If you don't, let's say if you only use 6 weeks, well, you still have the other 6 weeks in case you get sick or your baby gets sick or your spouse, but you cannot use it later on to take care of the, to bond with the child. Next slide. This discusses serious health condition. So one of it is if you're hospitalized, that immediately says that you have a serious health condition and you're entitled to protected FMLA. Or if you need continuing treatment by a healthcare provider. Next slide. Next slide. So the continuing treatment is you're incapacitated, or you have a chronic condition, or it's a permanent and long-term condition. Next slide. So if you're incapacitated, that means you have to seek treatment 2 or more times by a medical professional, and you also have to go for some sort of treatment. So it could either be, as an example, medication could be considered treatment, or also if you go to a therapist, that would be considered treatment. Obviously, if you keep seeing your doctor, then that's considered treatment. Next slide. This talks about, well, this slide is about pregnancy and parental care. So if you're going to have a baby and you have some, you're incapacitated before you have the baby, you have some medical issues, then that's obviously that's FMLA protected. Next slide. We kind of talked about this. Next slide. So this talks about a long or permanent condition. So sometimes with these conditions, you can either take the leave intermittently or consecutively, and we'll talk a little bit about that. Next slide. Next slide. Okay, and we have another poll question. Do you think any employer has denied you protected FMLA because you're a parent of a child with a bleeding disorder?
And that poll is open for voting now. And 100% believe no, that they have not been denied FMLA.
Oh, that's really good news. Glad to hear that. Okay, so the amount of leave that you have is 12 weeks. You can, and again, these slides are a little bit repetitive. It's for you to take care of your spouse, or for the birth of a child, or for your own serious health condition. So if you're going to take care of your son or daughter because of a disorder, then you have up to 12 work weeks. Next slide. Next slide. So this talks about calculating the amount of leave. So if you have intermittent leave, and let's say because you have to take care of your child, under the medical certification, if the doctor writes down that you may need from an hour to 2 hours, you may be late because of a serious health condition that your child has, then that's all that the employer can put down. So if you come into work an hour late or an hour and a half late, the employer can say, well, no, we're going to round it up to 2 hours. No, they have to round it to the time that you're actually taking. Next slide. This talks about special rules. What I'll point out here is basically holidays, because people don't realize it. If you're going to take continuous leave, so it's not intermittent, it's not that you took a day or maybe a half a day, but if you or your child, you need FMLA and you take, let's say, a whole week, if that within that week, let's take, for example, the 4th of July. So if you take that entire week and the 4th of July falls in there, then that whole week would be considered FMLA, meaning it's not going to be considered 4 days because you're taking it in a lump, and you're taking it in periods of a week. Next slide. So there's different methods to determine how much leave you have. The most common is called a rolling back method, and what that does is it goes back to the previous year. So if now we're in March, so now in March I say I need to take FMLA on March 14th, then the employer rolls back to March 14th of the previous year, 2014, to see how much time I have used on my FMLA. So if I have used 10 weeks, then I only have 2 weeks. If I had FMLA in January or February, that gets dropped off, and I kind of regain that time, and so I can have those. If I had like 2 weeks in January, I kind of recuperate those 2 weeks. Like they can only go back 12 months, and they roll back to the time that you actually request or the time that you actually need to leave. Next slide. Going to the previous slide, sorry, some employers do use the calendar, and what that means is that even if you have used your 12 weeks, let's say in November, starting in January, you get your full 12 weeks again. But normally we see the calendar year with government, like with city and state agencies. We don't see a lot of that in the private sector. Thank you. Next slide. So substitution of pay leave, FMLA is a non-pay leave, but the employer can substitute it for vacation or sick time or, next slide, workers' comp, disability, any other kind of compensation that you can get. And a lot of times it gets confusing because the employees say, well, I don't want to use my sick time, or I didn't apply for FMLA, I'm on workers' compensation. But FMLA can run concurrently with any of this leave because it's non-paid. So while you're out on FMLA, in order to get some money, if the employer has a policy that you're going to get some sick time with it, or you're going to get paid through workers' comp, then you're allowed to do that. The negative part of that is that if you have, let's say, 2 weeks of vacation, while you have FMLA for, let's say, 4 weeks, when you get off of the FMLA, you no longer have any vacation left because you used it with your FMLA, but at least you were paid for the 2 out of the 4 weeks. Next slide. When we started, I mentioned about communication. So it's good to communicate with the employer. The employer actually has a lot of responsibility in communicating with the employees. So they have to provide a notice. The notice is within 5 days. We'll probably see a slide about that. They have to maintain the health insurance, because obviously if you're out on FMLA and you're sick and they cut your health insurance, well, then you won't be able to seek medical attention. Or it'll be very costly. And when you come back from FMLA, they have to restore you to the same or equivalent job and benefits. And they have to maintain records for your FMLA time, whatever time you've used and whatever time you have accumulated. Next slide. So in the general notice, we have a poster. There's handbooks. It should be provided in the person's language if they're going to, if you have employees that don't really speak English. That's one of the requirements. Next slide. The notice has to be provided within 5 business days to let you know about your leave request. If you request leave within 5 days, then they let you know about it. They should be notifying you when you get the medical certification back from the doctor. They should also notify you that your leave has been approved. If it hasn't, or you're not eligible, then they also need to provide that that notice to you. Next slide. Here they show the rights and responsibilities. Next slide. I'm going a little quick because I don't know if I have enough time for all the slides, and I'm hoping that you'll be able to keep these slides. I should have asked that question in the beginning. Next slide, please. So again, this is all about the employer's notice of designation. So when the employer informs the employee, that can be verbal, but the designated leave, that has to be provided in writing. If the leave is within if you have a medical certification and that medical certification says that that it's valid for 6 months or it's valid for 3 months, the employer cannot ask for no more often than 30 days or the duration of that medical certification. So, for example, if you present a medical certification and you take off after 2 weeks, the employer cannot say, oh, we need another medical certification. They cannot require another medical certification until after 30 days. And if your medical certification has a date that is 3 months or 6 months, then the employer has to wait until the expiration of that medical certification to request another medical cert, even though you're absent. Next slide. The employer, kind of what we talked about before, they have to maintain your health benefits and the same terms and conditions as anyone that's continuously employed with the company. So you're treated exactly as if you were employed with the company. What I normally tell employers and employees is when you're on FMLA, you're kind of frozen in time. So for whatever benefits you had prior to taking FMLA, when you return, you have the same benefits. Everything basically remains the same. Next slide. Again, this talks a little bit more into about maintaining the group health benefits. Next slide. The employer has to bring you back to an equivalent job, equivalent pay, benefits, terms, and conditions. If it's, I'm not sure if anybody in this webinar is in this situation, but sometimes people work shifts that the company has shifts that they range within the 24-hour day. So if they bring you back to a shift that's totally unlike the shift you worked, then that's not restoring you to an equivalent job. However, if let's say your shift is from 8 to 5, but they want to bring you back for a 7 to 4 shift or 6 to 2 shift, that can be sort of an equivalent shift. We would have to see on a case-by-case basis, but you want something that's equivalent. You don't want something that's totally different. And the reason for it is we would consider that then that you've been discriminated against, or they're holding the FMLA against you, so then they're putting you in a shift that's totally different. Next slide. So this talks about what the employer cannot do. They cannot discriminate or retaliate. Again, if they put you in a midnight shift when you work a morning shift, then that kind of retaliation that would tell the Department of Labor they're retaliating against me. They cannot discharge you because you were out on FMLA, so when you return, they can't say, oh, we don't have your job anymore. So the employer is prohibited from taking any of those actions. Next slide. The employer has to maintain payroll records and copy of leave notices and et cetera, just like they would if you were working without taking the FMLA. Next slide. So now we come to the employee's responsibility. So again, we go back to that first slide with communication. So it's always good to let your employer know if you're going to take leave. As Ann mentioned before, it's not necessary to inform the employer if you have a serious health condition, but that condition has not surfaced, or if your child has a serious health condition, but they haven't had any issues. It's not important for you to mention that to the employer until it actually happens. But when the condition does arise, then it is the employee's responsibility to communicate it as quickly as possible to the employer, so that there is enough notice for the employer to try to substitute. You know, if you need to be out for a week or 2 weeks, and they know they have to get someone else, so it's good to kind of inform the employer. And also, if you're going to be out for a period of time, if you're going to be out for a block of leave, then it's good to let the employer know as soon as you know you're going to be out. Next slide. We kind of talked a little bit about this. Next slide. So the foreseeable leave is 30 days notice or as soon as practicable, and the unforeseeable leave is as soon as practicable. So of course, unforeseeable, you don't know what's going to happen, so as soon as it happens, you let them know. If it's foreseeable, then obviously, if you know it's going to be next month, then you can let them know ahead of time. Next slide. So the medical certification, I'm going to talk a little bit about this because this is important. The medical certification it's the main part of the of protection for the employee under FMLA. And the reason I say that is because the medical certification is what's going to let the employer know that the employee is going to be out for a certain amount of time. So the reason that it's called a medical certification is because the doctor is certifying you have a condition, or your children have a condition, or your spouse that requires you to be out. And you don't have to get a doctor's note every time you're out because you have this serious health condition. So that's what it certifies, that you have this condition, and this is when it flares up, and this is when you're going to be out. And the medical certification then serves the purpose of letting the employer know, okay, I know that when John Doe calls and he says it's FMLA and he's going to be out for 3 days, and I can get somebody to come and substitute for John Doe because nobody's doing his work for the 3 days. So that's the purpose of the medical certification. I always tell employees, please have the medical certification completely filled out, even if it's not applicable. Like, for example, if there's a section there for pregnancy that may not be applicable, have the doctor write not applicable. But just have it completely filled out so that the doctor, one, they don't skip anything that they shouldn't, and two, the employer doesn't have a reason for saying, oh, this medical cert is not completed, you need to get another one. So it kind of it helps out. Next slide. The medical certification shouldn't be provided to the immediate supervisor, and then the regulations will also be written, and I think the final rule was in 2009, and they kind of revised it a little bit. Prior to the final rule, an employer cannot contact or could not contact your doctor, but the employer can, as long as it's an HR person, it's not a direct supervisor. And also the employer, when they contact your doctor, they should only contact your doctor for clarification. They cannot contact your doctor to get more information. So the handwriting isn't accurate, or they can't read something that that the doctor wrote down, or there's maybe some conflicting information. They can just say, well, did you say this person would be out for 3 days or for 5 days? And then let the doctor respond, and then that's what the HR or the employer can, that's how they got their clarification. But they cannot go on and tell the doctor, well, what do you mean it's only 3 days instead of the 5? What's the reason for it? They cannot do that. So it's simply for clarification that the employer can contact the medical professional. Next slide. It also talked about second and third opinions, and the second opinion is if the employer tries to contact the doctor, they get clarification, but there's still something that's contradictory within the medical certification, then you can go and get a second opinion. The second opinion is paid by the employer, and if the second opinion differs from the first opinion, then there's a final third opinion. Whatever that third opinion says, that's what goes. That's what rules the medical certification. Again, we're back to the no more often than every 30 days. Next slide. Next slide. The fitness for duty, if you cannot come back to work because of your own serious health condition, or let me rephrase that, if you've been out because of your own serious health condition, then you would need a fitness for duty to return to work, and the employer is allowed to request that fitness for duty to say, yep, you can definitely do that job. You're not going to be in any danger. You're not going to get sick or injured for doing that job. Next slide. Next slide. So you basically, you can contact us at the Department of Labor if there's any kind of enforcement issue because of any violation, or you can also, the Act provides for you to have a private right of action, which means that you can get a private attorney and sue the company because they violated your FMLA. So those are your two options. Next slide. And I think we're almost done. And for additional information, there's our website. When you go into our website, I just want to mention, log in there and then go into FMLA. And FMLA is under, it's going to be under Section 225. So it's the Code of Federal Regulations, but it's Part 225. I'm sorry, Part 825. So anytime you see 825, that's FMLA. Anything with FMLA will be 825. And again, if you go on the website, just once you're in there, then just click FMLA and look for 825. Thank you. Thank you,
Jules. Just really quickly, would you mind sharing your phone number again with the audience?
Oh, sure. My number is 312-771-0962.
Great, thank you. Thank you to both you and Ann. This has been super informative, I think, for our audience. We do have a couple of questions for you, so I'm going to go ahead and throw those out there to you. The first one is, if for some reason I have an emergency where my son with severe hemophilia has to be taken to the emergency room due to his blood disorder, and I would miss work, would this still be counted against me, even though I have an emergency room note?
Is this question for me for FMLA?
Yeah, I think it could go for either one of you. So maybe if each of you can kind of answer it from an FMLA and ADA perspective, that would be great.
Yeah, so for FMLA, that would be as soon as practicable, as we went through some of the slides. So as soon as you hear, then you call into your employer and you let them know, I have a medical emergency. It's with my son, and then what you want to do is get, once you notify the employer, try to, if you can get a no from the doctor, then it's up to the employer to say to you, well, this looks like it can be a serious health condition, and they provide you with a medical certification. So at that point that you have that emergency, that's when you're kind of notifying your employer that your FMLA has started. But that would definitely be FMLA protected.
Okay. Anne, do you have anything?
Yeah, as far as the ADA goes, you know, if you have one of these employers that has these, you know, no-fault attendance policies, they're called, which where it's an attendance violation if you're gone for any reason, you know, under the ADA, even if it's a valid excuse for not being at work, I think, and having an emergency room note, even if you have all of that, if that violates the employer's policy that you were gone, ADA doesn't require that the employer do anything. You know, some of this is going to just depend on what kind of absences the employer excuses, but if you're gone for any reason and that violates the employer's policy under the ADA, that's not a violation.
So if I'm hearing you guys correctly, FMLA is your best protection in this particular example.
Yeah, I mean, in general, for leave situations, the FMLA is where you're likely to get your protection. The ADA doesn't offer a whole lot other than they have to treat you the same as employees who are gone for other reasons.
Okay. So another question, just to kind of clear up, because I heard a couple of different kind of circumstances here, and you said that when you're applying for a job, you don't necessarily need to disclose that disability up front. And Jules, I heard you saying that you don't have to necessarily acknowledge or disclose about the disability prior to there being a medical emergency. I guess my question is, I mean, hemophilia is very, very unpredictable. We know that we have foreseeable medical absences from work and surgery and that sort of thing, and it's foreseeable that at some point a child with a bleeding disorder is probably going to need their parent to leave work to come to them. But those are also unforeseeable in that it's just unpredictable. You never know when it's going to happen. So I guess the question is at what point as an established employee do you start that conversation with your employer and start getting kind of your ducks in a row to utilize FMLA somewhere down the road?
Ann, did you want to go first?
Yeah, I mean, it's a really tough question. I mean, you know, I think it probably depends a lot on your relationship with your supervisor and employer and how much you know, how much you trust them. I would think that, you know, the reason I say not to disclose that at the application stage is you don't want to give somebody, you know, an employer who has bad intent a reason not to hire you, particularly with hiring, because you really never know why you're not hired. You know, I think it's more difficult as an employee because, you know, people want to be responsible employees, and I guess it depends, you know, if you trust your employer and they're not going to misuse that information, you know, it may be helpful to start that conversation early so that they're, you know, if you do have to leave work, you know, you're not leaving sort of anybody in the lurch. But, you know, I wish I could give a really definitive answer for that, but it's hard to.
Okay. Jules, do you have any input?
I agree 100% with Ann, and you maybe with hemophilia is maybe a little bit different, but yeah, I agree 100%. Before you get the job, you don't want the employer to kind of say, "Oh, I'm not going to hire you," and again, like she said, you don't know the reason why. But the regulations does mention that, again, there's the communication and informing your employer as soon as practicable. But so with hemophilia, it may be a little bit different, that you may say, look, I can have this situation and this is what could happen, and can you give me a medical certification? However, some employers are really being very, I would say, strict and by the law, that they don't even want to give you a medical certification until you actually have an occurrence. And that came back from a ruling with the Supreme Court that ruled that you shouldn't be able to take FMLA. It used to be that when you knew that you had a serious health condition and it was a continuous condition like hemophilia, that you would be able to just get a medical certification, have it ready, so you don't have to worry about, okay, now I have to rush to the doctors or the hospital. I just can call FMLA and my employer has that information. Well, the law basically said, no, once you have the occurrence, that's when you want to call, that's when you want to let the employer know. But it also mentions about talking as soon as practicable. So it has to be, you know, whatever relationship you do have with that boss.
Okay. So another question that came in is, how can I prove I've been discriminated against if my employer is smart enough to not say something directly?
I mean, most of the cases we deal with somebody, you know, it's not as obvious as the one I had when the employer basically said, you know, essentially came out and said, I'm firing you because your daughter might be sick again. You know, you look at circumstantial evidence, you know, if there was, you know, if it's a situation where the employer didn't know that you had a child with hemophilia, and then once they find out, they start treating you differently, you know, you look at the before and after, and you compare them to the way they've treated other employees. You know, when we have a case, what we're doing is looking to poke holes in the employer's explanation for why they took an employment action. So if they're saying that the that the employee's performance went down, you look at personnel evaluations, and if there's productivity measures and things like that. I'm trying to think.
So it's really it's that historical piece and
yeah,
kind of compare and contrast.
Yeah, I mean you're looking at comparing the worker who says they've been discriminated against to other people in that job category to see if they've been treated the same or not.
Okay. Jules, any insight to that piece of that question?
For FMLA, how we see the discrimination is if somebody calls in, let's say because their son or daughter, they have to take them to the doctor's often or the hospital, then what the employer starts doing is, okay, well, you work the shift, then they start giving them another shift, or they start kind of reducing their hours. So it was a 37-hour employee, then all of a sudden, well, why am I only working 23 hours now? I need to, well, because you're never here. You're always at the doctor's. You're always at the hospital. So that's the only reason we reduced your hours. So for us, it kind of becomes a little bit more obvious because that's how we see it. And so that's kind of how we capture it.
Yeah, I mean, one example I just thought of in a case I've seen in preparing for this is it dealt with somebody, actually it was a couple they worked for the same employer, and their son, I think, may have had cancer. I don't remember the health condition. So they were incurring very, very high medical bills, tens of thousands of dollars, maybe even hundreds of thousands of dollars. And I think the employer was self-insured, so they were basically footing the bill for all of that. And they then started an investigation of the couple, arguing that they were stealing time from the company, that they weren't at work when they were supposed to be there. And so they ended up both being fired because the employer said they were stealing time. And the evidence that the court looked at and said that there was at least enough evidence for the case to go to trial was just the timing of this whole investigation, that it happened after there were these huge medical bills, that the company really, during the investigation, they really only looked at evidence that went against the couple instead of there was evidence in their favor too, dealing with how the company's punch clock system worked and things like that you could, and how you could get in and out of the security gates and things like that. So, that's just one example of how you prove it, where, nobody was telling these people, we're firing you because your son's medical bills are just too high.
Gotcha. Okay. Any other questions from the audience? This is the time to send those in really quickly before we wrap things up. And Elaine, if you don't mind going ahead and advancing to that final slide. Oh, it's not there. Never mind. Just wanted to let the audience know that these slides will be available on the HFA website under our resource library. In the coming weeks, we are putting together a whole toolkit with resources about FMLA and the American Disabilities Act. So be on the lookout for that. Be sure to like HFA on Facebook because that's where we will premiere and let you guys know that that is up and available for you on the website. But it'll have the recording of tonight's webinar. It will have the slides from tonight's webinar and some other downloads and handouts to just kind of give you a refresher course, because it's a lot of information, and I think sometimes we know that the laws are there to protect us as families with bleeding disorders, but we don't always put them into action until we need them. So that will be on our website and available. So with that, I do not see any other questions tonight, and we're a little over an hour here. So I just want to thank Anne and Jules for your expertise and taking time out tonight to present to us, and thanks to our audience for participating in the poll questions and sending in your questions. We really appreciate that. And in the next day or two, you will get an email again from us and just asking for your feedback. We really value community feedback at HFA and take that to heart, and is actually why we did this particular particular topic tonight because we heard loud and clear from you, the community, that you needed to know more about this topic. So with that, I will say good night to everybody, and thank you once again to Ann and Jules. We really appreciate your help tonight.
All right, you're welcome. My pleasure.
Thank you.
Good night.
Thanks, Jules.
Okay.
Good night, everybody.